Good evening, everyone. Welcome to our Libertas Chambers webinar. I'm Felicity, Gerry, King's Counsel, and I'll be speaking to you a little bit later on. I'll give you an introduction first, and we'll also be hearing from our very own Marie Spenwyn. The topic for today is defence openings and opening the summary of issues, how to frame what you'd say to a jury in advance of a trial. So we're very used to prosecution openings, but we've discovered during the course of our practice, firstly, that not everyone is aware that you can have these summary of issues at the beginning of a trial. Secondly, that are not being used as often as they should be. And what we found is that there's a practice growing of asking defence counsel, judges asking defence counsel to open one or two sentences in serious cases, which may not be the objective of the rule. It may well be that you can say far more than one or two sentences, which is something that we will explain today. Obviously, many of you will know me. Obviously, I practice in serious complex crime, usually homicide, terrorism and war crimes. Marie, one of our experts, also in homicide, serious sexual offending, and we both also specialise in financial offending. To explain the system for this evening, this is now the webinar system. Some of you may not be used to this type of Zoom situation, so it's slightly different from the usual chat. What you will see at the bottom is a Q&A function that allows you to click on that button and write your question in the Q&A, and I'll try and moderate those. I believe we can hear from you, so I can call upon you to speak, but the Q&A function at least gives me advance notice of what it is that you want to say, but we'll test out that system as we go along. As you can see, Marie is going to share a document with you. She will take you through that when she gives our expert presentation, and we will provide a version of that document in our next Libertas Lens newsletter. So what we do after each webinar is we type up the conversation that we've had with our experts, and we provide that in our Libertas Lens newsletter. So if you haven't signed up to our newsletter yet, please feel free to do so, because we do try and put interesting and useful criminal law, domestic and international criminal law issues in there. So we are being recorded, but you can't be seen on this webinar system. There's a little bit more privacy for our attendees. It's important to remember that there is enormous value in what we do for a living. So when you sit down and read the newspaper, it's quite rare to hear the defence side of any particular case. We often find that reports are made on the prosecution opening, and then the way in which the trial goes is not terribly well understood. I've spoken quite a lot about trials being televised. We may all have different views about that, but I've just spent a year in the International Criminal Court in The Hague defending Mr. Al Hassan, and every moment in court is recorded and put online. There's actually a 30-minute delay, so if there's any confidential issues, you have 30 minutes to deal with redactions and exclusions. But everything we do in court is recorded in the most serious of war crimes trials. So personally, I think there is an argument, at least, for being able to watch more of criminal trials rather than what we've got in England and Wales at the moment, which is just some sentences. That being said, it then seems important to think about members of the public who are coming in to sit on a jury. What are their preconceived notions about cases involving homicide, terrorism, fraud? How might you get your client's case across as early as possible? And until relatively recently, we would work on the rule of thumb that you wouldn't make a defence opening unless and until you could be confident that you were calling evidence other than your client. Now, we can already start to see how that might feel a little unfair. You have prosecutors who open a case maybe for a whole day, 2 or 3 days, depending on how complicated the case is. And in a sense, you don't get to reply until you're cross-examining the first witness. And then it doesn't really get your case across in the way that you might wish to get it across if you had the opportunity to speak. Well, you do. By Rule 25.92C of the Criminal Procedure Rules, you can put forward a summary of the issues. You don't have to wait to be asked. You could suggest it to a judge, and Marie's going to explain those rules to us. So I think it's really interesting. I think currently it's being used in a minimum form in very serious cases, but actually I think it's really useful in every case to be able to very early on give an outline of the issues in the trial. So over to Marie, who's going to give us the benefit of her expert research, and I'll come back in with a few stories at the end. And as I say, feel free to put your questions in the Q&A at any point. I will also think up some questions, so be on your toes, Marie. If we don't get any from our audience, I'll have a few prepared. But when you're ready, thank you very much for your time this evening. Defence statements and openings, please.
Thank you. Okay, so the document on the screen, I hope can be seen. Apologies that it's in the Word format, but we are, as Felicity mentioned, playing with this new webinar system, and for the moment it seems to be the best way to do it. So bear with me on that. It's a little bit unusual to see the whole Word document. Felicity's already given an introduction to what the aim of the session is. And in fact, there's not a great deal to the procedural content here, but I'm going to just go through it. Some people might be very familiar with it, others less so. And I think what's interesting is to think about the fact that a few years ago, there was a practice, particularly in fraud cases, of judges inviting the defence to make a sort of opening mini speech. And in every one of those cases that I've been in where that was the invitation, it was always declined across the board from the advocates in the sense of doing that. We've moved on a little bit since then, and now it's more enshrined. Well, it is enshrined, I should say, in the criminal procedure rules. But also there's a part of the Criminal Procedure and Investigations Act that relates to defence statements that we're going to look at in a moment, which meant that that power has been there, in fact, for a long time. And what I mean by that power is that a judge can actually say to the defence, if they feel that the issues aren't clear, and if they feel that something needs to be said to the jury at the outset, they have the ability to put an edited defence statement or aspects of it before a jury. And that's one of the things we wanted to focus on as well. It's not only the idea about what might be said, if anything, in a defence opening, if that's felt to be the right thing for the case that you're dealing with, but it's having an eye to how a defence statement is set out in case you end up in the position where a judge is going to say that that is what, under the power I've just mentioned, will go before a jury. And it's the sort of thing that you can imagine even thinking about it in that way is going to lead to argument and discussion. But anecdotally, a judge recently that I was speaking to was explaining to me the use of this power that they wanted to use in a particular case because, in fact, the defence case wasn't clear at all. And we'll all have been in cases where we know that we don't actually really understand what the case is that we're about to embark upon. So there are other tactical and perhaps ethical considerations that come with that as well. So those are the broad features of what we are going to look at together this evening. As I say, it won't take a great deal of time to go through these details. What this is focusing on is the idea about early identification of issues. And Felicity's already mentioned that we have to bear in mind there's a jury who may be well assisted by knowing what the issues in a case are. We have to balance that as practitioners against the fact that we've all long learnt that cases can change as they develop. Our instructions develop often in a case. And things may change, particularly where there's co-defendants and other issues come to bear during the trial. So all of those things we have in mind. So early identification of the issues could in fact be something that's quite tricky as practitioners to think through. But just starting at the beginning, really, the idea under the criminal procedure rules of early identification of issues is perhaps different to the option of having what we more traditionally think of, as Felicity mentioned, the idea of having a defence opening at the close of the prosecution case. That's still something that's provided for. It's still set out in the criminal procedure rules, although that's long been the practice, but it tends to not be used and strictly in reality couldn't be used unless there's a witness to be called other than the defendant. And that's what's on the screen in red. But everybody might be aware of that, even if it's very rarely used. What all are perhaps not so aware of is the power for a jury to be provided by the judge, as I've mentioned already, with a copy of the defence statement. Now, that power has been available since the amended Criminal Procedure and Investigations Act, and that's a section that's on the screen at the moment. It's subsection 6E. And in relation to that, it says, as on the screen, the judge in a trial before a judge and jury may direct that the jury be given a copy of any defence statement, and if he does so, may direct that it be edited so as not to include references to matters of evidence which would be inadmissible. Well, everybody would understand, no issue there, but perhaps the more important part is the may direct that the jury be given a copy of any defence statement. And that direction in subsection 5 goes on to say that it may be made of the judge's own motion or the application of any party, but may be made only if the judge is of the opinion that seeing a copy of the defence statement would help the jury to understand the case or to resolve any issues in the case. So that's really the essence of where this came from. There's a case called Connor that's on the screen now, a 2019 case. And in that case, there are many other points that in reality the case was about. But one thing that it drew out was a ground of appeal that was complaining about the fact that the criminal procedure rules provision for allowing a jury to be shown a defence statement were not in force at the point at which a defendant had completed and signed his defence statement. And the Court of Appeal weren't interested in that point at all, because they were saying it may well have been that the criminal procedure rule wasn't then in force, but the underlying provision that I've just been through in the Criminal Procedure and Investigations Act had long been in force. And on the screen, I've extracted the relevant paragraph of that judgment that deals with it. And as it said, the ground of appeal concerned the judge's ruling about a defence statement going before a jury. The argument had been advanced that the judge shouldn't have acted under the criminal procedure rule because it wasn't in force at the time the defence statement was served. The argument was found to be, as it says there in that extract from paragraph 29, without merit because of the provision under the Criminal Procedure and Investigations Act. So it is not, as it was said in the judgment, a new discretion. What is new, the last sentence there, is Rule 25.92C, the ability of the judge to offer defence counsel the opportunity to outline the issues to the jury after the prosecution opening. So that is what is new. That is part of what we're trying to focus on this evening in terms of trying to draw all of these powers and provisions together to try to give some assistance in terms of when they might arise and how they might be tactically used or not. So in red on the screen, there's a note that I've made that really draws together the point I've already referred to, that it will be important to advise when a defence statement is being prepared, not only of the general importance of the contents, of course, which we're all well versed in dealing with and making sure that a defendant understands that they may have to speak to during their evidence, for example, if the prosecution apply to put the defence statement before the jury. But it's a separate point. Some of you may be well aware of it, but many we've found are not. That there is the ability for the judge of their own motion to put that part of that document forward before the court. And in reality, what's happened, because it's been enshrined in a slightly different way in the criminal procedure rules, is that's going to become more likely. So as Felicity referred to at the top of the session, it's becoming a more common practice for judges to invite the defence to set out their thoughts in terms of opening. If the defence decline, then judges have the ability to say, well, they're going to do it anyway, utilising the defence statement. So perhaps the the biggest takeaway from the session this evening is that all of us, in preparing defence statements, be it as solicitors or as counsel advising on them, are going to have an eye to that when drafting them and when advising a client as to what it is that they're signing for. So turning on then to the specifics of that criminal procedure rule that we've mentioned a few times now. The rule is on the screen. I hope you can see it. And in reality, the first part that isn't in bold just sets the background that it applies in relation to, in essence, a jury trial. But the part in bold, 25.9.1c, where there is a jury, to help the jurors to understand the case and resolve any issue in it, the court may, first of all, invite the defendant concisely to identify what is in issue, if necessary, in terms approved by the court. We'll come back to that. And secondly, if the defendant declines to do so, direct that the jurors be given a copy of any defence statement served under Rule 15.4, Defence Disclosure, edited if necessary to exclude any reference to inappropriate matters or to matters evidence of which would not be admissible. So you'll see immediately how it mirrors and then expands a little bit upon the Criminal Procedure and Investigations rule that applies. People will have different views about this. When I read this, my instinct is one, really, I have to say, of horror, to think of the idea that many of the defence statements in cases that I've been in go before a jury, not because there's anything wrong with those documents per se, but because, as I've already mentioned, experience has long taught me that my case by the end of it will be very different perhaps to what it might have been in conference and in a signed defence statement. But in relation to this, what's been quite interesting in doing the pulling together really of the material for this evening's session has been looking at the criminal practice directions, because in the criminal practice directions, in relation to this aspect, you'll see on the screen now an area headed identification for the jury of issues in the case. And I've set out the paragraph there, but then I hope that you can see underneath in capitals, I've put that now these provisions have been removed from the very recently amended criminal practice directions. I haven't been able to discover and understand why that is, but the sort of enlargement of these powers was set out in these provisions that are set out on the screen, and as Felicity said, we'll make these available in a document after the lecture. But in relation, it's a little bit more, in reality, it's a little bit more guidance as to what it might be that a judge and or the defendant can do in relation to setting out these issues. But as I say, they have been removed from the criminal practice directions. So I'm not going to spend a great deal of time going through what is there. But it remains to be seen, as I say, quite why they were taken out and whether anything that's there in the sense of this further guidance will come back.
Marie, just to interrupt you, do you
yes.
to have a guess for a moment, can we just scroll back to that page?
Yes.
Can you see in 25A.2, in there it says the defendant is not confined to what is included in the defence statement, though any divergence from the defence statement will expose the defendant to adverse comment or inference. That's actually goes a lot further than the criminal procedure rules.
Yes.
Which have, perhaps we might call it, a more powerful status. So do we think there's a clue there that these are removed so that you only get to stick to what's in your defence statement and not going outside of your defence statement? Maybe that's a clue. What do you think?
Well, very possibly, and I think if you could sort of look for different things in this, really, I think of it now as a bit of a blurb. It's a bit of a sort of, oh, here's a bit more about this, and this is what you can do. And it might well be that it's been thought that that was perhaps too much in a number of different ways, including the idea about inferences, because of course that's all governed by many different provisions that we'll all be familiar with. So that could well be exactly as you've spotted.
Yes, perhaps a removal of a threat, but also the removal of allowing full openings. It's restricted to an identification of the issues. That's a guess, but thank you.
But moving on to how it is now, and we might be able to sort of follow that through into this. This is the position as it applies, that goes hand in hand with the fact that a judge can direct the jury about the relevant law in a case at any time during a case, in relation to something that the court thinks the jury will be assisted by. And that's the provision that's on the screen at the moment. Because the idea, in reality, it seems to me, behind these provisions, it is designed to assist the jury. Felicity's spoken about that already. But if there are issues that are going to be set out in opening at the outset of a case, in the sense of what the defence case will be, a judge in conjunction with that is then able to give a jury initial directions in a case long before the stage at which they may ultimately have done it in the old-fashioned way right at the end of the case, now perhaps in a split summing up with written directions as they must be. But the power is there for the court to give jury directions about the relevant law at any time if it will assist the jurors to evaluate the evidence. So it's difficult to look at one part of this without looking at that bigger picture as well. And on the amended criminal practice directions that are on the screen now, you'll see there 8.5, jury directions and written material, early provision of directions. It says there the court is required to provide directions about the relevant law at any time that will assist the jury to evaluate the evidence. The judge may provide directions prior to any evidence being called, prior to the evidence to which the direction relates, or shortly after. And in red, I've put the examples that Archbold currently gives in relation to the sort of early directions that might be given in a case. Turnbull directions, for example, in an identification case, directions in relation to the use of special measures, or in relation to any sort of vulnerability aspects for the defence, designed to assist. And I've been in cases certainly where early on a judge has given a written direction to a jury in relation to the use of the Section 28 procedure and the fact that they will see cross-examination as well as the recorded evidence of the complainants in the case. And I've been in cases where with my agreement, I'm not sure I could have stopped it, but certainly it seemed to me it was the right thing to do in those ones where the jury get an early direction that says, don't hold any of that against the defendant, which is why certainly I welcomed it in those cases. So certainly these things are starting to gain some traction, and there'll be many different examples that people will have of those. But moving on in terms of the wider, perhaps more significant legal concepts that might intertwine with issues that the defence might wish to set out at the beginning of the case, are the ones that follow. Knowledge, dishonesty, consent, recklessness, conspiracy, joint enterprise, attempt, self-defence, and so on. You can see them on the screen. Now, these are just examples that Archbold have set out, but I thought it was quite helpful actually to start to think about the idea that at an early stage in a case, in the way that many of us are not familiar with, that a judge could start setting out quite key, significant directions long before the evidence has been heard, long before those directions are targeted to the evidence that might arise in the case. In relation to the early identification of issues and how that fits in with those matters that I've just been through, I also went to the bench book on this aspect in terms of early identification of issues. Now, bear in mind that this hasn't been revised since the revised criminal practice directions. But what the bench book says, as on the screen, and I've highlighted particular bits, I won't read it all out to you because you can read for yourself, but it reiterates the fact that the criminal procedure rules encourage early identification of issues at trial, and that requires the active assistance of advocates in that endeavour, as it's called, and the provision of early legal directions whenever it would be helpful to the jury. Now, the next section there, subsection 1, you'll see it says in the bench book that the trial judge may invite the defence advocates to identify the issues immediately following the prosecution opening speech. It's not an invitation, it says, to make an alternative opening speech, but merely to confirm that any short statement of the issues in the Crown's opening speech is accurate, and if not, to correct it. Now, that's another interesting potential spin that could be interpreted in different ways. Often those on this session may have sat through prosecution openings where you get some perfunctory, almost summary of a defendant's interview, for example, in a way that doesn't bear any relation in reality to what it is that is a defence case that's being put forwards. But the part I've highlighted in yellow is this: there remains no right of the defence to identify the issues at this stage, and whether the defence advocate is invited to do so is a matter for the discretion of the trial judge. So that's something to bear in mind.
Yeah, I'm just going to interrupt you again for a moment, Marie, because I said at the outset you don't have to wait for the judge. And I was going to explain that later, but it's probably a good idea, and tell a story later, but probably a good idea to explain it now. Because it's a judicial discretion, it seems to me you can ask. You can ask the judge to invite you. You can ask the judge to offer. You can't ask to do it. You haven't got a right to do it, but you could say, actually, this is a bit complicated. We'd quite like to set out the issues. Can we do that? And if the judge refuses, that might be quite interesting if the case does get complicated later on. I'm not saying you would have a ground of appeal, but it might be a bad start to a trial if a judge says, no, I'm not going to tell the jury what the issues are. So I don't think you do have to wait for an offer. You could put your feet in front and say, judge, please invite me to outline the issues, and I'll explain and tell a few stories a bit later on, but I thought it was probably right to mention that there, so you don't think I've gone completely mad. Thanks, Marie.
So what that section goes on to say is that as a matter of practice, it may be wise for the judge to invite the defence to supply a short list of bullet points in writing in advance. And then I've highlighted this part in blue, so that the limited scope of the exercise is clear to all parties. Now, I know that one of the stories that Felicity will tell you shortly will be focusing on exactly the ability of the judge to request that in writing and then effectively to red pen it. And I'll leave that to her to come back to. But that's why I've highlighted that part as well.
Well, I can chip in a bit here if you don't mind. So I've drafted 9 paragraphs, got red pen down to 3, and then got it back up to 9, but amended. So I think it took several emails and no problem with the judge at all. Once I explained why I wanted some of it back in, it's relevant to this, it's relevant to that. So you might be in front of a judge that doesn't know exactly what the relevance is of the bits that you're trying to talk about. So it was limited in scope. There were 9 very short paragraphs and a prosecution opening of 2 days. That's not very much, is it? So it was a limited scope, but it does mean you've got the opportunity to get potentially 9 paragraphs before a jury, because I've done it. Anyway, I'll keep telling that story later on. I couldn't resist, Marie, sorry.
I think what that's showing though is that it's the sort of thing that advocates are going to be prepared to deal with, or have to be prepared to deal with, to get engaged with a judge in relation to that. Some judges will want to say, oh, it just says a short list, or it's just meant to be a few points, and then try to control it in that way. Others may say, well, look, in fairness, if we're doing this, it should be done properly. And I think there'll be quite different views about whether that's appropriate, depending on the case that we're dealing with. I can think of many cases where, as I've said already, I wouldn't want to say anything. Other cases, for example, a murder case I can think of that I was involved in last year, where we did think it was appropriate to summarise key aspects of our case very shortly after the prosecution's opening. But I think really the flag there is to say that it doesn't mean that it has to be confined without argument. It doesn't mean that somebody else can decide, because of course at that stage it's very rare for the judge and certainly the prosecution to really understand what the defence case is, because that's part of the system. This bench book guidance goes on to say this: if the defence advocate declines having been invited to do so, I've already said I've been in many cases where that in fact has been the views of the defence advocates. The judge may direct that the jury be supplied with the defence statement suitably edited, and I've already been with you through the 2 sources where that power comes from, the CPIA as well as the criminal procedure rules. It then goes on, the bench book, to link it, as I've been seeking to do this evening, with the setting out of the issues through to any early legal directions. And that's what the next paragraph on the screen does. Once the issues have been identified, the trial judge can consider whether to give legal directions to the jury and in what form. And that's where those other sort of broader directions might come into play. Another area in which it's very likely that the advocates will get engaged with the court in terms of whether that is or isn't appropriate. But the bottom line seems to be that these provisions are all there, that they're here to stay, they're being expanded, they're being developed. And I think it remains to be seen how they're going to be used in different cases going forwards. It's a sort of thing that I have the impression of that some judges will be quite in favour of, other judges will just carry on as normal, and others may have a mixed practice, just as we might in the view of our own cases, think that it's appropriate in some cases and not in others. So there we are. The example I did give earlier in brief terms about the detail of it, the anecdotal one about a trial where a judge was minded to put a defence statement before a jury, it wasn't a homicide case, it wasn't a fraud case, it wasn't a case that would be in any way one of those that I might myself have thought of previously as the kind of case where this would come up. And what that said to me was, this is the sort of thing that's being fed through, be it through the Judicial College and training and so on, but it's something that's going to become more commonplace and something that we will need to deal with more often as practitioners. Which brings me back to the point I've already mentioned in principle, the eye that we need to have as practitioners to draft in defence statements. First of all, thinking about how what is within a defence statement could be adapted or summarised or reduced into a way that we might be comfortable with as an opening, potentially to avoid a judge going the whole hog and putting the whole defence statement forwards. Because it seems to me that where that's going to become an issue between the defence and a judge is where the defence are saying, well, we're happy to say these perhaps few lines or 9 paragraphs in Felicity's example, but where we're happy to do something, but then the judge starts saying, but that's not what it is in your defence statement, so I'm just going to put the defence statement forward. So I can see there can be a real tension that might come up in that way, which brings us back to the fact that we will have to have an eye to this when a defence statement is being drafted. And everybody will know that the approach to defence statements will be so different depending on the client, depending on the case. I did a trial just last week where, in fact, I drafted, I think, the longest defence statement with the assistant of my solicitors that I ever have in a case. But it's because a young vulnerable defendant had lied and lied and lied again in his police interviews. There were many good reasons for those lies, and in due course that was all dealt with in the trial process. But the defence statement was an opportunity for him actually having accepted the reality of his case to put it forward. So there were good reasons there to set out a very full defence. Whether I would have been happy for that to go to the jury is a very different matter. It was done for very different reasons, to send some flags to the prosecution and to the judge, in fact, as to the other arguments I was putting forward, as to evidence about the vulnerabilities and as to evidence about the lies. So that's just another example in relation to thinking that sort of thing through. And that's why the second point on the screen there is having an eye to how matters are set out in a defence statement with a view to taking account of that risk that a judge might allow the edited version. And edited really is quite specifically in relation to any inadmissible matters to go to the jury at the outset under either of those key provisions that I've set out this evening. And also, when dealing with defence statements with clients, we all well know now that it's important to make sure that a defendant does sign a defence statement, of course, because it's their document, it's they that may have to speak to it in cross-examination. But this is another aspect to put in our things that we've got to remember to advise in conference, that a client is advised of this potential when they're signing this document, that a judge could say that the document can be happily handed out to the jury along with all of their other bits and pieces that they get. So that brings us on and covers in a way already some of the headline points in relation to the tactical considerations that there might be that I've tried to think about in principle while taking you through the basic provisions. But the other interesting phrase that's used in the criminal practice direction that's now moved on and been much reduced, but in the original one, there is this phrase, dealing with superintendence by the court. And it's that aspect of tactical consideration and that aspect of tackling things with the tribunal, and that I'm going to hand back over to Felicity to say a little bit more about.
Thanks, Marie, for taking us through all those differing pieces of rules and guidance that we now have to follow. I suspect it comes from some dissatisfaction from judges as to the quality of defence statements. You do sometimes hear that from judges, even when there's not that much wrong with the defence statement. They sometimes don't like the way that they're written. So I suspect that was the impetus for these rules and guidance. But what I thought I'd do now is tell a few stories, as I like to do, just about when this has arisen in cases that I've done in England and Wales over the last year. So in one case, we were invited at the very last minute to put the issues before the jury. It became fairly obvious that other counsel in the case were just going to sort of make it up, and were trying to butter up the judge by saying, oh, well, it'll be very short, it'll only be 1 or 2 sentences. And the judge kept saying, yes, 1 or 2 sentences. And I thought, well, actually, that doesn't get my client's case across. So I'm not going to just stand up on the hoof and come up with 1 or 2 sentences. So I pulled out several paragraphs from our defence statement, almost word for word, and put those into a document and sent it saying, this is what we want to say. And that was those 9 paragraphs that went down to 3, then went back up to 9. And in the end, if it did go down to 3, I suppose this never happened, but the judge I could have then refused. I could have said, no, I refuse to say those lines. I never did. Obviously, this didn't happen. And the judge was great about it. I'm really interested in the additional parts that I'd put in. I was able to argue relevance, and it was no problem with the judge at all. But it did make me think, actually, I could refuse, and then my defence statement would go to the jury. And much of what I was saying was already in there, and it was quite a good document. So I absolutely agree with Marie. There are some documents that you definitely don't want before the jury at the beginning. But this was one of them. So I felt like I had a little bit of power, even though the judge could, of course, withdraw the invitation. But it was a really interesting exercise to engage a judge in a very early stage and to put the defence issues early. You know, if you've got family members watching, family of the deceased, members of the public, it's an exercise for the jury, but also an exercise in public information and education that we don't have very often. I appreciate that the rules are designed to help the jury, but I actually thought it had a really interesting use in this particular trial. If you've got the press and the public present, they can really understand what's going on. I've had another trial, equally complicated, in which the judge prepared all his directions on the law and the summary of the issues of what he thought the defence cases were. And that was a handout for the jury to be given to the jury before we started the trial. And we were enabled to send in suggestions, either in writing, there was a moment orally, where we could contribute to that document. And we did, in fact, identify quite a complicated area of law that we sort of did enough to explain to the jury at that stage, with a view to explaining it in more detail down the line. And the judge indicated it may well be that he would take that document away and give them another one. So that was quite an interesting exercise to see whether or not the jury would keep the same document, have it taken away. You could think about how would that document influence the jury. I mean, it was very simple, outlining the issues, outlining the law, but I thought a really useful handout for the jury. Maybe hard for them to understand very early on in such great detail. I wasn't so sure about the law, and especially in some cases. So if you were doing, for example, a joint enterprise murder where there's contradictory defences between clients, it might be a bit risky by the judge, because you might end up leaving the case to the jury on a different basis from the way in which, in law, from the way in which the prosecution open it. And we know that prosecutors don't always open the way in which they want the case to be left to the jury in the end. So again, this is going to happen. Judges are going to look at the defence statements and draft their own documents of their own motion, and then simply ask you to amend, tell you they're doing it, and simply ask you to contribute to amendments, and sometimes in not very much time at all. That part I find really worrying. I think you should have time to think about these things. The third situation I've had over the last year was a client refusing to do a defence statement and then being asked what my case was, and me having to say, I'm very politely, I can't answer your question. We're putting the prosecution to proof. And it was a really, really difficult case. In fact, the defendant filed a defence statement 3 days into the trial, but at that stage we were putting the prosecution to proof. And so we were not engaging with the judge. And of course, the defence statement we had filed said we're putting the prosecution to proof. So the judge plainly didn't say it in these terms, but plainly didn't want to give the jury our defence statement. So we didn't decline. We drafted something that was sort of similar, which was basically, it could be anything. Have a look at self-defence, and it could be anything. And in the end, the judge decided 1 or 2 sentences meant he's challenging everything, and he does not accept that he was the killer or something along those lines. I can't remember now exactly what the judge said. So you have to think about those cases as well, where your client refuses to engage. What if the judge wants to give the jury the issues there? And ethically, what can you say and what don't you say? It's very difficult ethical exercise on that one. You have to be quite robust to withstand a judge when you're saying, I really can't answer your question. So it's a really interesting development that I happen to love in many ways, that I can open my case to the jury is very useful. But equally, I've been in those very difficult cases where I'm not so sure I want the jury to know all of the issues that might come out as we go along, especially if we've got issues with co-defendants in the trial, or we might still be waiting on expert evidence. We might not know what the issue is. We all know how bad it is with funding for experts and last-minute experts, particularly around perhaps cognitive issues of our clients. So active assistance to a judge, as the language tells us, can be actively assisting the judge not to give too many issues, as well as actively giving over as much as possible. In all of those scenarios, what I've found is that judges are limiting themselves to what are the issues within the prosecution case. So even if you're running a positive defence, so if we think, for example, the case that I've just done in the International Criminal Court, just to use it as an example, we had their issues of mistake, superior orders, and duress. You don't quite know whether you're going to have that evidence by the end of a case. Do you really want to be saying it at the beginning? Well, there we were asked, and we had to file a trial document, and it was there, quite a lengthy document setting out what's known as the trial brief. So we did. Positive defences were in there, the law on positive defences were in there, and you're giving that to 3 judges. So you're giving the law and the factual dispute to the judges in writing, and I believe they're available on the website. Most documents in that case are. Think about the same circumstance here. If judges are reluctant to talk about positive defences, they might have to if it's a modern slavery defence, because you're going to be cross-examining about the circumstances of your client. So they may be reluctant to leave duress to the jury at a very early stage, but they ought to be persuaded to leave a modern slavery defence, if that's what you're saying, because there it's likely your client's going to be admitting the conduct, but giving all of those reasons. And I think that's really interesting. While we've got these terrible restrictions on expert evidence in modern slavery trials, you're going to want as much in as possible at the beginning, because you're going to be struggling with expert evidence if the authorities continue the way they are, wrongly in my opinion. So you've got to start thinking about fact and law, even though it's meant to be, it looks as though it's factual issues. It must in certain cases include legal issues, and it must in certain cases include some positive defences, not necessarily all. But in one of those cases I've told you about, of course, one of the issues for one of the co-defendants was alibi, and that formed part of the beginning of the trial. So the jury knew straight away that that was the issue in the trial. So when Marie talks about make sure your defence statement is useful for this purpose, the first example I gave you was really interesting because I could basically cut and paste those 9 paragraphs, not exactly the same, and you're going to change the wording somewhat for opening of the issues. So it's almost worth saying, in short, the issues are, so you give your discursive defence statement and then have a sort of in short paragraph that might set out the issues that in the way that you're going to say them. What I've done in one of those cases, I can't remember which one, is I've emailed the solicitors in advance and say, how about we asked to do a defence statement of issues. I don't know if we're going to be asked in this case. Maybe we ask to do it. How about this content? And in fact, we were asked, so we didn't have to request to be offered or invited. There's some frustrating parts to it. So nobody takes a red pen to the prosecution. How many long-winded, boring openings have we had to sit through? How many openings that actually occasionally misrepresent the inferences that can be drawn from the evidence? So the document in writing might be fine, but then prosecutors stand up and embellish on inferences, and you might not want that saying. To what extent can we begin to say, well, surely it would be fair to red pen the prosecution? No provision for that at the moment, but it's quite an interesting development that judges receive written openings, don't amend those, leave it to us to say to the prosecution, well, actually, could you not open this paragraph or not open that paragraph? But what do you do about the flourishes? If you know they're coming, I think I'd just have a conversation now. I don't want you talking about inferences at this point. Well, I'm going to ask the judge to tell you not to. So I think you're getting a little bit more control defending, not much, but a little bit more than just sitting there and waiting to see what happens. Other areas where I think it might be useful: women who kill, vulnerable people who kill when they're subject to coercion, really serious cases of homicide. I think this is going to be really interesting. People with diminished responsibility, explaining unfitness to plead might be quite interesting. Judges at the moment say it's an issue of fact. Judges probably deal with all of that. You don't have a positive defence, so you can't put anything positive forward, but you might want to say, well, hang on, when we're looking at whether they've committed the acts, the issues that we'd like you to think about are X. When you're considering the acts, consider this or consider that, not just this person isn't well, but here's the issues that are going to arise. And you may be able to identify some of those, and that you're not putting forward a positive defence, but you're asking a jury and a judge, obviously, to think about the issues in those types of cases. And I think particularly controversially at the moment, cases where it's alleged that young people are part of a gang. You might really want to say early on something about gang and gang related material. If you've not managed to get that material excluded, and there is quite a lot of good jurisprudence now on how much of that should be excluded, then it may well be that you want to give some sort of opening about how the jury should approach gang issues, because it's an issue in itself in a trial that you're likely to be suggesting that this is unfair labelling of your client, and some may use rather stronger language than unfair labelling. I'm not sure you'd get that in a document on the issues. You might get that in your closing address later on, but I think cases involving gang allegations would be really interesting. And obviously financial crime. Some jurors are going to be really nervous about maths and systems and complex accounting. So what I always love to do is work out how the system worked or didn't work as the prosecution suggests, because there's always a worry that there is a system but it's not the system that the prosecution are suggesting, or where you can find a hole that demonstrates that this was a usual financial transaction rather than a criminal financial transaction, or a usual piece of behavior rather than some form of international corruption and bribery. And in those types of cases, you're really going to want to say, hang on a minute, this is how you need to look at this type of human behavior before you even get to the maths. So often in cases involving financial crime, these types of openings, we'll call them, have been around for a very long time. But I think these rules allow you to bring some human aspects to it as well, not just the financial issues, but the issues as a whole. And we've seen that in cases with clients with autism, for example. And I definitely think this is really useful to try and explain any cognitive limitations your client might have. Obviously, you're running it all by the judge. My instinct is you do that in writing, so the judge knows what's coming. But others are still dealing with it orally on the hoof and in one or two sentences, with that, which personally I think is a shame, because I think it's a good opportunity to get the defence case across. But I do recognise there will be those sorts of cases where actually you want to wait and see what happens before you start giving too much away. So as Marie has said, these are tactical decisions. I think I'd call them strategic. These are strategic decisions that you're making in full knowledge of what your client's case is about, or in situations where your client's refusing, you're still making a strategic decision to put them in the best position possible at the very start of the case, so that the jury really understand what the case is about. And I think to end on this, there are those cases where you do just want to sit it out and you might not need to ask a question. You might have to sit for a week or 3 months, depending on the case, and literally say nothing and wait for a submission of no case to answer or a closing address to a jury. And just imagine that, what that actually looks like for a jury, that the defence is saying nothing for the whole of the trial. It might actually be really useful to stand up and say, well, actually, we're saying these 2 paragraphs or these 2 sentences or these 9 paragraphs on these quite complicated areas of law, this human interest part of the case, and these factual disputes. So, look, I'm really glad that we've had some of you turn up to listen to us today and to understand our concerns and our joys, can I call them, that something for the defence has finally come into the criminal procedure rules. Also, look how up to date we are. Marie's giving us the new 2023 practice directions, so very up to date. So we hope that's helpful for you. As ever, I imagine we'll all go away and worry about what we're going to do with our next defence statement and what we're going to do with our next client who may or may not engage, how we're going to do it because of the difficulties getting into prison and seeing clients, whether that's on CVP or in person, how we're going to persuade a judge if we want to do this and the judge is not interested. How can we persuade judges to exercise their discretion and offer us or invite us to have that opportunity? What we're going to do if it all goes horribly wrong, that you've opened the issues as they were at the start, and then at the end it's completely different and your clients perhaps said something giving evidence that completely changes the framework of the case. What are you going to do in those cases where you're presented with a surprise or a fundamental change in the way that the case is? We've all had to deal with those situations. We haven't necessarily had to deal with them when we've opened something ourselves. But be reassured, in those types of cases, it's certainly usually traditional that the prosecution have said something like, we anticipate it's going to be about X. So in the same way as you once in those trials said, well, the prosecution anticipated it was going to be like this, in fact it's like that, don't hold it against him, let's see how we go. I'm sure you could draft a really great closing address that helps the jury understand that everything can be decided in your client's favour. That's really what we're all there to do. The last thing I want to say is that obviously these statements of issues at the beginning, I run them by the client. I do not make these up on my own. I will tell the client what I think should be said. I will give the client an opportunity to be involved if I'm given the time by the judge. Not always, but if I am. And I haven't yet had to say, actually, can I have a bit of time to talk to the client? It's always been in a situation where I was ready for it. But the other thing that I've started doing now that other barristers don't necessarily do, and I like being a little bit controversial, and Marie will know this from when we've done cases together, I will give the client a draft of my closing address. An early draft, not the final draft. And obviously I'll always run that past the junior, but I've been in cases where silks have not even shown the junior their closing speech, which I find quite surprising. I don't know anybody else that gives a draft of their closing to their client. Maybe there are other people who do it, or maybe they just go through the topics, but I think that's really useful as well. Give the client the respect to see what you're going to say about them, and then the confidence to let you add to that in your final version, which might go through 3 or 4 changes after the version that the client has seen, but they can broadly see what you're going to say. I tend to take those back because they're only a draft, so I'll give them a draft and take it back. But I also think that's quite useful. So your client's involved at the beginning and involved again at the end. There's no rules about that. Nobody has to copy me, but I have found that clients have been pleasantly interested in what it is that you're going to say about them in court. So it's another option to think about. I send it to the junior, copy the solicitors in, and invite everybody to comment, good or bad or indifferent. Okay, so I've been watching the Q&A while we go through. I suspect we've answered most of the questions that you have. I can't see any others. What I will say is, and I said it at the beginning, but maybe for those of you who joined a little bit later, I know sometimes timing is an issue. What we do after these webinars is we write up what we've said. We put it into our newsletter, the Libertas newsletter, with a link to this webinar. So you will receive a video recording and a written version of what you saw of Marie's presentation with my input beginning and end. So what I've said without giving you a handout will be in the newsletter when we get round to doing it. So I suspect you'll get that later this month, or more likely in July, in our next newsletter. So I think we've only got 3 minutes left, so we can finish slightly early. I don't know whether there's anything that you want to add for the last couple of minutes, Marie, other than a hurrah at how up to date we are. I'm very proud of us. And
the thing I was thinking of, just as I was listening to what you were saying, was about the recent article in Counsel magazine written by a juror. I think a lot of people have seen it, where basically they sat through what appeared to be, from what was said, a long fraud trial, and had many questions about what actually is going on, and who speaks when and who's doing what, because it was a case where there was multiple counsel, for example, I think 3 perhaps for the prosecution, and these things were never explained, and on reading the article you realise how much we all take for granted that we've become familiar with that isn't obvious to juries. And that aspect of what we've been talking about this evening, in terms of if this is genuinely to assist a jury and in the positive way that you've found in it, then wonderful and great and good. I'm a bit more sceptical about whether that's really what it's about, and whether it's more about trying to pin issues down and the things that we've already foreshadowed could go wrong. And what I find it hard to think about is losing that one moment that I most enjoy when I first get to my feet before a speech, which is to say, this is in reality the first time you've heard properly from me. So I think I would miss that, because juries sit up and listen to that. But that's to balance against all the other possible positives of it that you've been through, Felicity. So I'd say jury's out on this one, whether it's a good or a bad thing. We have to keep an open mind.
Yeah, absolutely. And it might be a very bad thing in some cases and a very good thing in others. So I don't think I'm giving a broad brush for every case. I just have found in the cases I've done over the last year that it has been quite useful. I'm less enamored with the idea that the positive defences are not in there. I don't like that. I think if you're going to do it, it should say what the case is actually about, but we'll see how that goes. Will be really interesting in, I think, cases like women who kill in the domestic and family violence situation. You know, how much are you going to be able to say about the deceased very early in those issues, and about the circumstance of the accused person, and particularly women in these types of cases that carry so much publicity? How much are you going to be able to say at that very early stage? And then is it valuable, or is it unkind to your client if her whole case can't be before the jury? Of course, I'm not suggesting only women would be on trial in those types of situations, but those are the cases that tend to catch the public attention. And I think those are the types of cases where this is going to be really interesting. How much can you actually say? If judges' practice is to not allow anything positive, that's really not fair. So when we're thinking about fairness, it doesn't feel fair. And those are the sorts of cases where your cards are on the table and you want it all out there. And we might have issues around bad character and hearsay that are really not resolved yet. So could be quite complicated. But so watch this space, going to be really interesting, case by case basis, as ever, as the Court of Appeal would say. Don't forget the law, the evidence, and the challenge. And I think I'll leave it, Marie, on, well, isn't it great to hear from the defence and to understand the defence case when necessary. Thank you very much, everyone. Thank you to Marie. Thank you to Gerry, one of our clerks at Libertas Chambers, for hosting us this evening on our new webinar platform. It's not a new platform to everybody, of course, but we hope it's been helpful for you, and we look forward to posting it on our YouTube channel in the next few days. Thank you very much indeed. Bye-bye.